appellee wants to save time on SIR rebuttal, so that will come out of your 30 minutes. Okay. Is the appellant ready to proceed? You may.
10 minutes at the end for rebuttal, if I could.
Well, I'm not sure, the SIR rebuttal will be last, so.
Well, that would be rebuttal. Anyway, may it please the court. My name's John Dent, and I'm the attorney for Crapo, who's the property appraiser for Alachua County, Florida. Paul Donnelly is here representing the appellee, who's the Academy for Five Elements, that is opposing us in this. I want to state at the first that if I have a hard time hearing, I've been ill with water on the inside of my eardrum, so sometimes I'm trying to hear what's happening. But be that as it may, we're here because this court granted an en banc hearing with reference to a decision rendered by the panel in this matter, which held in effect that the doctrine that we had of each year standing on its own with reference to ad valorem tax matters was not applicable now at this point. And referred to it.
Hold on, counsel. That's not what the panel held, was it? The panel simply held that the doctrine of res judicata can apply to value adjustment board hearings, but certainly an assessment issue, because values change every year, would never apply there. We're only talking about the legal issue of an exemption and whether res judicata applies to a prior determination of value adjustment board with absolutely no change facts, correct?
I do not see, no, and I would disagree that that's the law previous to this decision, that VAB, in fact, the decisions, some of which came up that we've been relying upon, they were actually either ag class or exemption cases that the doctrine was applied. And so that is, each year stands on its own. In your decision, which was the Macedonia case, involved an exemption, and what the court, the trial court in this case, had in fact ruled that this is the decision and we're mandating the property appraiser, you're bound by that into the future. And this court stated in the opinion, no, that's not the law, is that you can't do that because of the annual application and reconsideration each year by the property appraiser of the exemption. And that's been the law of both value and exemptions in the case. And basically, what you're elevating is a decision that was rendered in an administrative body that has no legal experience in rendering a decision, and then you're challenging Mr. Crapo, who's made a decision not to, it's not an appeal, as we know by the Supreme Court decision, Williams versus Law. What it is, it's a de novo circuit court suit, not a hearing or hearing of an appeal by the court based upon a prior record. So you have a de novo process. Now, I have to go back because of what's evolved in the law. This all started at a time, these cases out of a time when...
Well, counsel, let me ask you before you give us a history lesson here. You would agree, would you not, that the doctrine of res judicata can apply in administrative proceedings?
Generically, in an administrative proceeding, yes, but not of the nature of this type of hearing.
What about this type of proceeding makes the doctrine inapplicable here? That's what I think we're all trying to figure out, is what's different about this type of proceeding. Is it the adjudicator? Is it the procedures? Is it the judicial review or lack thereof? What are the characteristics that this proceeding lacks that makes the doctrine inapplicable here?
Okay. Starting with the VAB process itself. As stated by the courts, this is a process which is, quote, originally envisioned the layperson can go in without attorneys, without litigating, without discovery, et cetera, to present a case, with the idea that they would get a result. Then, if either party in that process, okay, was unhappy, they could file a de novo lawsuit in the next level, the circuit court. One case said that while that decision of the VAB is admissible in the circuit court, it has no presumption in the circuit court. So it basically goes away in a de novo process. That's generally not true of administrative proceedings that are under the Administrative Procedure Act.
Wait a second.
Where if you were,
Let me stop you there right there, because everybody's been talking about the Administrative Procedures Act. We have administrative finality for local government type decisions, code enforcement, zoning, where they talk about, res judicata, that you can't bring up the same issue again. So do you need the formality of the Administrative Procedures Act to have administrative finality? I mean, that would seem to go against all that local government case law.
well, I'm not sure what local government case law you're referring to.
There is some
There
case
are-
law, believe me, that talks about administrative finality at local government decision-making. They don't have discovery at the local government decision. They don't have necessarily all the formalities of the APA, but administrative finality applies at the local government level.
I don't, and correct me, and I'm ignorant.
It's not been cited, but believe me, and I went back and looked at it.
Yes, I don't remember seeing an appellate
Okay,
decision
so what,
that made that determination that we could look at and rely upon. What I see is that in the local level, I'm assuming your rezoning hearings or issues like that and what their process is in going to court is really totally different. I've never, maybe there is one, a case that is held that if you had a rezoning hearing and you lost, that you filed for the next year another rezoning hearing, that the res judicata prevented you from a reconsideration.
change in circumstances, most certainly does.
Well, maybe so. I'm not aware of a decision that we saw that we could look at and rely upon in the context. The only decisions, like the one cited by the court, involved where you had a process that it went in front of an administrative body governed by the Administrative Procedure Act, where there is an appeal of that directly to this court, I believe, the first DCA.
So, hold on now, I think you're getting to the answers to my questions, but thus far, the only thing I've heard you say that makes this body different is the lack of a direct appeal. You have a de novo appeal rather than judicial review by an appellate body. Are there any other differences?
Yeah. The concept of the process, if your ruling stands, and that's the law, you've just changed the nature of the VAB process to no longer being one of a simple process prepared by taxpayers and property appraisers. Because now we're going to go in, okay, and look at that and make, first of all, discovery, do everything we can with the knowledge that we're going to go immediately into circuit court de novo, because we can't make a decision independently to say, well, we'll wait to a different year for whatever reason and litigate this in a better context, et cetera. But you're going to force me to advise my client, the other attorney, and taxpayers to say, watch out, this is your shot. And if you don't, be prepared. If you lose, you're going to circuit court because you're done forever. I don't believe that's applicable in other contexts of administrative procedure. This process was designed years ago.
It may have been designed years ago, but the administrative rules that govern the process, I've gone through them, the 12D9 rules really mirror the procedural rules that govern a proceeding at DOA. You have prohibitions on ex parte communications. You have an exchange of evidence. You have procedures to disqualify or recuse the board members. You have procedures for conducting the hearing with cross-examination. So I guess other than the fact that this is a de novo review in circuit court rather than an appeal, what is different about this administrative process that the general rule allowing res judicata to apply doesn't?
Well, the other that I mentioned is that In this matter, you have laypersons, two county commissioners, and a school board member making legal decisions.
How is that different than
Because generally the process.
well, how is that different than the health board, the board of nursing, for example?
Because that's what they do, mostly. They do a lot more of that than meet once a year and hear several petitions.
So we're gonna decide whether certain boards are more qualified than others. That's the difference you want us to make.
Well, I understand, but in the context of what the board in this case was designed to do, and in the context we have here, you're saying that their decision, the VAB decision, rises to the level of a law if we don't appeal it.
What case law guides our decision on determining whether an administrative body's decisions should be given preclusive effect? What is it about the dignity of that body that needs to be in place, and what case law governs that analysis?
Well, I think, first of all, in the case that was cited in the proposition, as the courts have generally held, that it's extremely rare to actually apply this doctrine in any administrative process. So we start there. Now, in that case, I believe you had the body, the administrative body, made a determination, a well-reasoned determination in a prior application. I think it was a rate case, or it was a rate case regarding contracts, et cetera, that they made a determination in this matter, we do not have jurisdiction. In that case, the ratepayer chose not to appeal that determination of jurisdiction. Then the court said, in a rare case where it was blatantly decided that we do not have jurisdiction, that we're not going to revisit that jurisdictional issue regarding us to hear the same case regarding the same facts. I don't think application is a general term is applicable to administrative process. Like the court said in that case, it's rare to apply it. Now what we have is a value adjustment board with law that goes back to the 70s, stating that in whatever the matter, when it comes in front of the VAB, okay, that there is no requirement that you have to appeal that each year stands on its own. So in this case particularly, advising my client that in this matter, no, we're not bound, there's no decision that we're required to follow and go forward because each year stands on its own. I started this years ago.
From a policy standpoint.
Excuse me?
Let's look at this from a policy standpoint, because I want to really understand why it's a good idea to do this, apply administrative race judicata or not. You keep on saying, well, this has been the tradition. I'm not sure the case law is that totally clear out there about that. So what I would like to know, excuse me, I'm getting old here and I've lost my train of thought, but it seems to me that as a property owner, why should I be required, if the property appraiser wants to come in every year and there's been no change in circumstances, why should I be required to go hire an attorney? And I know that you're saying that attorneys don't have to appear, but they can. And if it's a big exemption, they're going to get an attorney. Why should I every year as a landowner be required to hire an attorney just because the property appraiser decides that they want to go after me again?
Well,
And if there's been no change in circumstances?
I'm going to suggest to you the remedy that was suggested in the Spencer versus Havel decision, where you had multiple challenges. Now, in that case, Ed Havel, year after year, was challenging the ag class. But the court said is the remedy is against him doing that is you have 57-105, that it gets to the point of being frivolous. You bring him up for sanctions and let him start
But
paying
how
for
can it
each
be,
of those.
excuse me,
In that case,
counsel.
it was multiple
counsel,
years.
Counsel, how could it be subject to 57-105 sanctions if the law is, this is not necessarily a hostile question, but if the law is the property appraiser can relitigate, challenge annually an exemption, well, then that can never be subject to 105 proceedings.
I'm not sure that I agree with you.
Well, I mean, if we hold in your favor.
Yeah.
And we issue an opinion and say, administrative finality does not apply. Property appraisers can challenge the exemption every year if they so choose. Well, a property appraiser who did that would not be mounting a frivolous action. That would be authorized. So it wouldn't be subject to 105 bad faith type sanctions, right?
Well, the fifth, believe that it was, that the property appraiser could be ridiculous.
Well, I'm asking you.
Excuse me.
I'm asking you, not
I
the
agree
Fed.
with that decision. I think, yes, the property appraiser.
But how does that logically follow?
Because
if we
it's
issue an-
frivolous time after time if the property
Why?
appraiser does nothing more than challenge it and then drop it. Challenge it and drop it. At that point in time, I think that's exactly what 57105 was intended to do.
Who are you saying would assess the sanctions, not the VAB?
No, and remember, you're doing this by going into court, and the court would do
But
it.
I thought-
If not, I think the VAB, the taxpayer, could go into court and ask for sanctions.
But your point is that even if they did go to circuit court, which then, and the circuit court decided it applied for 1 year, I thought your argument was just limited to the VAB. You're saying that even if the circuit court says, yes, this exception applies, or this exemption applies, that would be revisited at the circuit court year after year? I thought your whole point was
No,
this.
the multiple challenges, and I think, don't get me wrong, I think property appraisers can abuse the process, and they're subject to sanctions.
But my question is, if the circuit court decides this issue, then is there res judicata as to that?
If the circuit court ruled and we didn't appeal it, yes, we would be bound by that circuit
Okay.
court decision, because it's a circuit court decision.
Okay.
Now, you're asking me in a future year, and again, I'm not sure which aspect you're saying of the circuit court. If I challenged and the circuit court said, and granted the exemption, and said they are not, and then I kept applying the circuit court, then I'm abusing the process on it. Now, like you said, if the circuit court...
Because of res judicata.
Yeah, if the, well, not, I'm trying to go through and reason through the process this court did in Macedonia. They had a circuit court that said, and this court acknowledged there was no change in the law or the facts. But no circuit court, you couldn't mandate that the property appraiser was required to apply that in the future until the law or the facts changed. It's a circuit court decision. You all struck that down. It said you can't do that. You can't bind future years on exemption determinations under the law. Each year, now what's changed is that it used to be annual applications. Now that statute's still there. There's a local option, which says that a county commission can opt to have automatic renewal. Then there's provision that if the property appraiser believes in any year that there's a problem, he can force the new application. So new facts can be developed and provided to justify whether or not the exemption is still eligible.
Well, counsel, last time you were here, you're saying there wasn't any new facts, correct? You stood before. Last time you were here, you said there were no facts, no change in the law, nothing has changed from the original exemption to 2014. Now let me finish. I've got a little more to say. Nothing has changed factually or legally, correct? I mean, you said that last time.
The basic facts we're
Okay.
relying on for the
So-
interpretation have not changed.
Okay.
We're, you see, I think,
Well, let me, I've got some questions. Please listen.
okay,
How many tax years are at issue? How many tax years has Mr. Crapo gone after them on their exemption? It's 2008, 2014, any other years?
in 2008 did nothing until we initiated this one. Now we've challenged it each year just to preserve.
Each and every year, you said, right?
Huh?
A number of years, what, 15, 16?
They're pending.
But
yes.
nothing's new or different. How can you justify the property appraiser continually seeking to overturn this exemption year after year when nothing has changed? Where's the reason behind that?
Because the matter's pending in court, if I waive that right to challenge those future years and I should win, there's nothing can do to go back for those years.
Future years, if something changes. I mean,
Well-
but nothing, you've stipulated that nothing has changed. So why should a property appraiser have that type of authority to, again, year after year after year? This is 4 years now.
You're getting into a procedural act that I don't think is really in this setting. You're telling me that I should do the 1 year, rely upon it. If I win, tough luck. You're lost all the other years. You didn't do anything.
No,
You didn't
here's-
appeal
here's
it.
my-
You didn't
Here's
do
my modest
anything.
proposal. The opinion in this case was crafted in a way to say, if you can come up with any change in facts or any change in the law, great, but otherwise, it's done and it's binding. Now, I don't think that's a fairly difficult burden to overcome, in my view at least, to come up with something factually or something legally different.
I understand the argument. In advising and relying upon what this court said, as I said, in the Macedonia decision, there was no change. The court stated that in their opinion. There was no change in the facts of the law. That's why the trial court said, until there's a change in the law or facts in the future, property appraiser, you shall continue to grant the exemption, period. No change in the facts, none in the law. And this court said, no, you can't do that. It's
Now we're
not-
sitting as the full court, so we're not bound by the Macedonia case to the extent we were bound by it as a panel. I guess where we're all, at least where I'm trying to get an understanding from you is why shouldn't, I mean, Judge Makar's laid out some good policy reasons that res judicata should apply to the decisions of the Value Adjustment Board. I'm trying to hone in on what are the legal reasons that it shouldn't. And the only one I've heard at this point is, well, the two that I've heard are the review is a de novo trial rather than an appeal, and your argument, which frankly I don't accept, but your argument is that the procedures that occur here are less formal than a DOA proceeding. Are there any others that legally would distinguish this type of proceeding from other administrative proceedings where it has been applied?
Well, I think those are significant difference than other proceeding, as is the VAB process. Now, my question is, we're here automatic renewal. Would we be here if we were still under the annual application statute as decided in Davis? There, every year, and that's where this evolved out of, was that every taxpayer claiming exemption had to justify it every year. Now, are you saying that this rule now is that irrespective of that, the property appraiser, if they filed an annual application every year, he cannot deny it, he's bound by what they decided in a prior year because of a VAB? And that's not been the law, that's what you looked at. I think the process of the VAB and the nature of the proceeding is not such to air out complex issues of law and fact.
Okay, can I ask you one other question? And I think I've really discussed this in the brief. This doctrine of administrative finality,
Yes.
is that a question of statutory interpretation, or is that a question of a judicially imposed finality?
That's
You understand
judicially
me?
imposed.
Pardon, both?
I know of no, in fact, when I read the decision that, that's cited, it appears there that they were citing the law as, generally speaking, this doctrine is not applicable to administrative proceeding. It's only in a rare instance is it done. Now, you've got an instance where it has never been done. The implications are that each year stands on its own, and now we come along with a different decision and applying a process to an administrative process that I don't think is designed to air out complex issues.
Okay, the reason I asked the question, and maybe I can make it clearer, you make one argument in your brief that I found interesting that's really not made here, that the statute provides that in certain cases, like for agricultural exemptions, there is some kind of administrative finality.
Yes?
If we're dealing with the question of statutory interpretation, like, hey, what is it, exclusionis et ulterius? Is that applicable here?
Well, what the court held is that there was no administrative finality in that statute by the legislature, because the court reasoned if there was, it would be unconstitutional. What the Howard decision found is that the requirement regarding future years on tangible personal property value was nothing more than a ninth factor that the property appraiser could consider and reject. It rejected the concept that this court held that part of it was unconstitutional because it created a separate class. The court below, it came up on a constitutional challenge where it had been held unconstitutional because you can't pass a statute that has that effect of mandating that a future year is bound by a prior year. So the court in Howard said no, but how we're going to get around it, it's not binding on anybody. The property appraiser fully can consider, reject what the VAB did, and establish a value. The same thing with the Tifton case. They got around the idea that it was binding on a future year and said, essentially, such a precept would be unconstitutional. You can't do that. And that's the theory that we're arguing here, is binding a future year, tax year, saying that if you had a VAB, you went to it, and you lost, you better go to circuit court, because we're saying whatever they decide is now binding between you and that taxpayer. And remember that
Mr. Dad, you're closing in on 4 minutes left. You have
me?
4 minutes left.
And Chief, we haven't addressed the appellate argument, the direct appellate argument at all yet. We've been
No.
stuck on the cross appeal. Can you please, before your 4 minutes are up, address your appellate argument and whether this entity is an education?
Whether this is an educational institution, yes, I can. I think, first of all, there's no obvious case law, but I think the only case that I can cite that has bearing on it is a Supreme Court case in Bush. Now, in this scenario there, remember, it was an adoption of a provision that provided that we would give money to students that wanted to go to private school if school they went to was declared below a certain level of approval. And that went to the Florida Supreme Court. And the Supreme Court said that, look, there's a statute. And that statute says DOE has no authority over private schools, period.
Now, the CIE in this case is under the governance of the DOE, so you're making a distinction between the DOE and the
Commission?
The commission.
Yes, yes.
Even though the commission answers to the DOE, or it's under the DOE governance in the statute.
I understand, but I think if we read the statute, we read the determinations, a commission is totally separate and apart. It's its own entity. It makes its own decision, has its own budget, adopts and provides its own rules. It is specifically separated from DOE's control and that statute that says we have no authority to regulate private schools. If you read the commission's whole statute, they do not regulate the private schools. What they do is require disclosure for publication and so that they can qualify to do business in Florida. Congress recognized that in the act because our act, the Education Act, what it says is for accreditation, we're going to look to those accrediting agents approved by the United States Department of Education. If you read their statutory provisions, they single out accreditation. They have a whole other section that talks about this area idea of the commission, and that is what are the requirements to license somebody to do business. They delineate it is not an accreditation. Accreditation is a review to determine quality. Supreme Court says DOE has no authority to do that.
Well, the commission does require them to submit
They're-
courses and schedules and all sorts of things.
They're
along the
required-
lines of what are you doing? Do you have a degree program actually in place?
Yeah, it's disclosure. They don't have a policy to evaluate whether that disclosure reaches to a certain level of accreditation. All they have to do to get a license, in fact, if you look at their rules,
Accreditation isn't the only word used there, right?
Excuse me?
Certification. Accreditation isn't the only word used there. Another word used there is certification.
And the commission doesn't certify anything.
Well, doesn't the definition of license say a certificate?
No. The definition says you're taking a noun, which is a certificate, and converting it to a verb, certification.
Well, let me approach it this way. The Academy argues that if we agree with your interpretation, then there is no non-public college that would qualify for the exemption. Do you agree with that?
No. Certainly don't agree.
Okay.
Many of the colleges have accreditation, either from SACS or from a recognized agency of the federal government for accreditation. They do have accreditation, but they also have licenses. You know, what surprised me in researching all this, the University of Florida that I attended, they're accredited by SACS,
By SACS.
not by DOE, not by the commission, not by any other agency. They're accredited by SACS because that is an accrediting body. It's a determination of the quality of education. That's what accreditation does. Licensure, if you read the whole statute and the reference, it's a disclosure. They're required to submit their schedule, not because commission is going to say, oh, that's good, and we're going to put our stamp of approval on it. It's no, that's good because you've adequately disclosed. In fact, I pointed out in part of the rules,
Isn't it that
there's
you
some
prove-
schools
you
that don't
prove
even
that-
have to have it.
Hold on, let's,
Excuse me.
let Judge Osterhouse ask a
Yeah,
question.
It seems like they're not getting into the substance of what you're teaching if you're an acupuncture institute or a seminary or a private law school or what have you. They're not doing that, but they are verifying that you're an educational institution, that you're
Who is verifying that?
the commission. By submitting your courses, by
They're-
submitting your
they're-
schedules,
they're-
they're actually verifying that, okay, this looks like an educational institution.
Well, they're verifying that you make certain provision in your brochures, et cetera, disclosing what you offer. If you offer a certain level of degree according to the statute, then you're required to disclose how you provide the necessary hours, et cetera. But they have no criteria. The Academy has an accreditation from somebody that can
Okay, Mr.
evaluate
Dent.
the viability.
Mr. Dent, I'm going to ask you to sit down. You're way over your time. Now, I'll give you some more time. We'll work through this so that it flows smoothly. I think I'll ask the appellee to go ahead and address all your issues. If you still need a serve rebuttal, we'll do that.
Very well, thank you, Your Honor.
Thank you. And please give the appellee 2 more minutes.
Thank you.
May it please the court, I'm Paul Donnelly with Donnelly and Gross, representing the appellee of the Academy. I'm going to take the first part of my oral argument and address the decisional finality issue, and I was going to deal with the educational exemption issue last, but I think since it was the last question and most recent, I think it's very important to point out that the commission, at issue in this case under the Department of Education, regulates all private post-secondary schools, colleges, universities that offer advanced degrees and other degrees. The statement that they don't regulate private schools is absolutely incorrect. Private schools at the kindergarten through the 12th grade level are not regulated by the Department of Education. It is true that the statute is specific that those schools are freer of regulation. Post-secondary colleges, schools, whatever the phrases are required to be regulated by this commission under the Department of Education. So the statement earlier about private schools not being regulated only applies to K through 12. Turning to the administrative finality issue. Our Supreme Court has ruled, first, that the VAB process in Florida is quasi-judicial. Court held that in the Redford case back in 1985, which we cite in our brief, our supplemental brief. That involved the Department of Revenue, whether the Department of Revenue had the ability to sue over an exemption involving the Miami International Airport and the leasehold there. But very clearly, the Supreme Court stated that the value adjustment boards, which at the time were called property appraisal boards, same statutes, same types of boards, are quasi-judicial. Second, our Florida Supreme Court has held clearly that failure to appeal from a quasi-judicial determination results in decisional finality.
Well, that, counsel, if I can take you, I was probing Mr. Dent about what makes this administrative body different than any other administrative body that res judicata can apply to. And the two reasons he gave me were, one that you just touched on, that there's the appeal, uses that word in the statute, is really a de novo proceeding at the trial court. And that is a distinction between, or that is a reason that this administrative body's decisions do not have res judicata effect, whereas those that the review is through an appeal do. Can you address that point?
Yes. Justice Alito, in writing for 7-2 majority in the B&B hardware case in 2015, directly rejected that argument. We cite that also in our supplemental brief. He cited to the restatement second of judgments and rejected the argument that de novo review of the administrative panel, in that case it was a trademark board that decides some trademark disputes, that just because the review of that board is de novo, that has no bearing on the application of decisional finality. And again, I think it's fairly easy to avoid decisional finality if you have, I mean, the courts have been very willing to dispense with decisional finality on the facts of a given case where there's a change in the facts, a change in the public policy or law.
When there's a change in the facts, you're not even worried at all about decisional finality, about res judicata, about anything else. Like there could be a U.S. Supreme Court decision, but if a party demonstrates different facts, then the U.S. Supreme Court decision is going to apply. So it doesn't really make any difference whether there's a change in facts. Either it's entitled to administrative finality or it's not. Correct?
And the legislature that set up this board and this whole process doesn't speak to that at all. Is that right?
Doesn't speak to what?
To the administrative finality argument, to the ultimate issue here, which is whether you can go back to the VAB year after year with essentially the same issue.
Well, I mean, they don't have a statement in the statutory scheme that specifically codifies judicially recognized doctrines of decisional finality, but the legislature's scheme intends that by establishing a very specific appeal initial review process through the Value Adjustment Board, with procedures that are really very analogous to the Administrative Procedures Act, and then an appeal to the circuit court. The property appraisers were granted the right to appeal to circuit court from adverse rulings of the Value Adjustment Board. And in that same Supreme Court decision from 3 or 4 years ago, the B&B hardware case, Justice Alito noted that if the legislative branch intends decisional finality not to apply, the legislative branch will need to state so and be clear about it.
Well, what's the purpose then of having a taxpayer having to apply every year, I mean, absent the local option, if administrative finality just puts it into the question, absent a change of circumstances?
Well, because it gives the property appraiser an opportunity to know that taxpayer is still there and present, and I don't think it has any bearing on the fact that decisional finality applies. The property appraiser needs to look at it and determine whether there's been a change in circumstances, whether the property appraiser has every right to request additional information or documents from the property owner. The application itself has no bearing on whether decisional finality applies. And that...
Well, isn't the application something that forces the taxpayer to show that no facts have changed?
Yes. Yes. And the statutes are clear that if facts change, the burden is on the taxpayer to notify. I mean, does that happen? It would never happen if you didn't have to put an application in every year, some sort of form, and these are all Department of Revenue forms. They're not invented by the
With res
taxpayer.
judicata, the burden to show some change that overcame would be on the party that's bound by the res judicata, right? But you're saying here it's different, it's your client's burden to show that nothing has changed?
No, I think they're just submitting an application.
Well, whose burden is it to show?
Actually,
So the next year, under your view, if nothing has changed, they can't revisit it. Whose burden is it to show that nothing has changed? Or to say that something has changed?
the party seeking the change in circumstances.
Okay, so it would
But-
not be so your client would have no burden to show.
Not other than the application. Yeah, but actually, that's not correct, because in Alachua County, the county commission voted to waive the requirement, that local option, to waive the requirement of an annual application. What the academy's been confronted with year in and year out is notices of denial of applications that they've never even filed. Notices of denial of the exemptions, excuse me. And then we go right back through this process every year.
Counsel, I'd like you to address another aspect of whether decisional finality should be accorded to the VAB. Is there something about the VAB itself, its composition, whether it's accountable or not, bias? There were some issues that were raised in the supplemental briefing about the implicit bias the express bias that some of the commissioners may have on the VAB, and why those decisions should not be accorded finality.
First of all, the scheme contemplates that if there is bias, there's an opportunity to recuse and these things. And the scheme contemplates the Department of Revenue providing training, and that there be a separate lawyer, independent of the property appraiser, who advises that board, among other, and then the other trappings of due process. But I would submit that those kinds of criticisms can be made of any quasi-judicial body. They simply can be made. For example, we know that in the case of the county zoning boards, which we talk about in our supplemental brief, in the Coral Reef case, you have zoning boards. I mean, these zoning boards are appointed by elected officials in these places. The other case we talk about the county code enforcement hearing officer process. These people are also appointed. I don't think there's this sort of nebulous idea that the board could be biased is not a factor in the decisional finality. I mean, if there's evidence of bias, you can do something about it. One thing is you appeal to the circuit court.
What about the concept that, ad valorem taxes are different? Department of Revenue versus Howard kind of implied that for certain circumstances, you couldn't have total preclusive administrative finality. Is there a problem with the Constitution? I mean, your federal cases are out there, but we have the Florida Constitution that deals with property taxes.
Well,
Do you understand my question?
I think so. I think
I mean, are we constraining the property appraiser in a way that the Constitution doesn't contemplate?
Absolutely not. There's no constraint on the property appraiser. If he has a change in circumstance, he can challenge the exemption.
What if the change of circumstance is just is just the value of the property? So there's some huge enhancements. In other words, the VAB comes along, rules contrary to the property appraiser, and their property appraiser says, given the value of the property and the value of the exemption, it's not worth the hassle. And then 3 years later, the property quadruples in value through some additions or whatnot. Would that be enough to revisit it, or would the legal issue of whether the entity, because one of the arguments against the administrative finality is you don't want to put the state or these government actors in the position of having to go to the mat over things that maybe don't matter that much to them for that one reason. That's why you don't have issue preclusion against the government in a lot of instances.
Well, no. If the exemption applied,
Right.
and there was a litigated determination of that
At the VAB.
at the VAB
And no
and
further.
special master and magistrate and all that, and the property appraiser failed to appeal, and then years later the property tripled in size or value, that is not a factor in the exemption analysis. So we still have an identity of all the issues.
Okay, so the answer is that the change in circumstance has to go
To the exemption.
Yes, okay.
It would need to go to the exemption. And actually, in our case, the academy nearly doubled in real estate size during this time period. The Academy literally bought the old Social Security Administration building behind the federal court. It's behind the federal courthouse in Gainesville is where the Academy is. And so they bought they had the first building there where they got the exemption in 2008. And then several years later bought the old Social Security Administration building next to it, with a bunch of classrooms and clinical settings in there. So it doubled in size, but that has no bearing. The size of the institution is not a factor for the
So what if the change of circumstances was a different property appraiser? Property appraiser A was really loose and everybody was exempt, and new property appraisers reading the statute and saying, I don't agree with that. I'm gonna follow these statutes.
I think, sir, I think that it's the governmental entity and not the individual elected to that position. And I think that underscores why decisional finality is important, so that the parties aren't left to wonder with the changing, political winds, if you will, what's going to happen with these exemptions.
Is there a distinction between assessment and exemption for this analysis?
Oh, absolutely. You mean value assessment?
Exactly. So that is something to which administrative finality does not apply, assessment, just simply valuation?
The panel said it does not apply, and I cannot imagine, and I agree, and I cannot imagine, and as I argued to the panel and in the briefs before the panel, I cannot imagine a situation where a valuation case could ever be subject.
So let me ask this, your response to the last question.
Yes, sir.
And follow up to Judge Roberts' question. So let's say you have, and I'm not suggesting there are any, but let's say you have a negligent, incompetent property appraiser. Doesn't know how to do their job, doesn't properly protect the government's interest in taxable property, doesn't care. A party buys 30 acres on 441 North in Alachua County, prime real estate, tells the property appraiser, I'm going to run a horoscope school. And the property appraiser says, sounds great to me, you're exempt. Doesn't even require documentation from the commission. That binds all future, and so of course, that property appraiser doesn't appeal. He agreed. So that binds all future property appraisers forever?
I don't believe so, because as I understand your hypothetical, which is not just hypothetical, happens every day, the property appraiser grants the exemption. And then subsequently, a new property appraiser is elected, or this same property appraiser changes her mind. That property appraiser is allowed to do that because the original granting was never litigated.
What if it was? What if the Value Adjustment Board, the first time around, for whatever reason, approved the exemption, and that property appraiser, who initially appealed to the VAB, then drops the appeal and doesn't pursue it? All future property appraisers are bound?
Yes, because it has been litigated by the property appraiser, for example.
But aren't you
Alachua County.
binding future property appraisers? I mean, there's a general rule that legislatures cannot bind future legislatures. Do you think a constitutional officer can bind future constitutional officers?
I think it's got to happen every day. I mean, and in this case, it would be the case. I absolutely believe that the law requires decisional finality where all of the elements are met. And one of those elements is not because the decision maker or one of the parties is a governmental decision maker who may change in the future. I do not believe that is an element at all.
Does anybody
Nor
else
should it
have
be.
standing in that VAB proceeding to go to circuit court other than the appraiser and the property owner?
Yes, I believe the Department of Revenue would have the ability to contest that. Because all of these exemptions and forms and the findings of the VAB, they go to the Department of Revenue. The Department of Revenue is supervising these things, or at least, has the ability to.
The administrative finality issue looks to be a pretty close issue. The statutory issue, in my view, seems a little more clear. If we were to affirm Judge Monaco's decision on the statutory issue, find that the exemption applies, why do we need to even address the administrative, or do we need to address the administrative finality?
We do need to address it. because there's not a better set of facts to demonstrate why decisional finality should have been applied and why why the academy should not have to go through these years and years of litigation like this.
But I guess that's a institutional or bar-related reason why we should need to address it. For your particular client, if we rule the trial court was right, your client is an educational institution, you win this year, you win next year, you win all these years.
That's true, of course.
On the question whether your client is an educational institution, the only question I have there is the Florida statute that talks about the granting of a license is not an accreditation. I understand your argument that there are other things other than accreditation in the statute certification, but what is the practical effect of that particular sentence that I just read to you? If it doesn't apply in this situation, when does it apply?
It would apply in circumstances where, first of all, the statute on the educational exemption outlines 3 different bodies who can give you the stamp of approval for that you're an educational institution. One is the Department of Education. The Department of Education doesn't accredit. However, the other 2 agencies, like this Southern Association of Colleges and Schools, accredits. And the third one, excuse me, I believe the Florida Council on Independent Schools, which is the third one, may also accredit.
Okay, but
Finality. Go ahead.
I'm not sure I understand, though. I mean, your argument is that the approval of the Department of Education is sufficient to make you the educational institution under the statute. This language that I just read is in the same portion of the statute. The granting of license is not an accreditation. I'm trying to, within the statutory framework, what is the meaning of that? How does it practically operate?
I believe that I understand accreditation in the statute to be consistent with the normal definition of or understanding of accreditation, and that would be by a body that is vetting for accreditation purposes, and the Department of Education isn't, say, accrediting you as a nursing school or as, but they are certifying that you meet all of the requirements to protect students who are earning these degrees. In the case of the academy, master's degree, bachelor's degree, for example, that these are degrees that are require general education, require certain courses of study, and the voluminous regulation that goes into this certification that the academy has to have.
And acupuncture is regulated, right?
Yes, it is. But there is an accrediting agency for the academy, and the academy is accredited. It's an association. It's a separate association of those types of schools.
Counsel, the administrative finality issue, as was res judicata, was raised in the trial court below. Is that correct?
Absolutely.
Had the trial court addressed that issue and ruled in your favor on the issue, the trial court would not have reached the merits of the claims. Is that correct?
Yes, sir, would not have reached the merits. And we also raised this issue at every step, at the special master step and at the value adjustment board step, in addition, of course, at the circuit court and this appeal.
If you could, I asked the question earlier, how many tax years are at issue? Was that correct? Is there the original one and 3 others?
Okay, we have 2008, and then we fast forward to 2014. So we had a hearing in 2014 where no change in circumstances, and the special magistrate just ruled the opposite way. The value adjustment board overturned the special master, and the property appraiser appealed. Again, denied the exemption in 2015, and those are consolidated cases in the circuit court. 2016, we go through the whole process again, and the parties agreed to stay that case. And now in 17 and 18, I'm here to tell you, we're right back at it.
So there's a challenge to those years as well?
Absolutely, and we've prevailed again.
So if we decide the education exemption issue, this process can go on year after year and year and burden your client. I don't know how big the business is, but is that correct?
It's really not that gigantic. I mean, they've got, I think that the graduating classes can range from 10 to 25 students, depending. It's a really involved course of study, actually, over several years. So it's not that huge. And answer the question earlier about the property change over here, it's, doubled in size geographically. But,
Well, how would the issue continue if this court, in a published opinion, said that your client was an educational institution for the purposes of the statute? And maybe you didn't say it was. The question was, couldn't this, if we didn't address the administrative finality issue, if we just addressed the statutory, do you get the exemption issue?
but he could then challenge it again.
Well, we've said it, though. I mean, it'd be pretty frivolous for him to say, you're not an educational institution if a DCA has said that you are, and nothing has changed, course-wise, certification-wise.
That's interesting, because there was a question earlier, would decisional finality, or the appellant argued in response to a question earlier, that decisional finality would apply if the circuit court ruled. Well, doesn't that destroy his argument that every year stands on its own? It logically makes no sense to me, because he'll make that same argument. There's nothing to prevent him from making that same argument. Each tax year stands on his own. We have multiple briefs in this case, right, at the trial court level, the panel level, now at the en banc level. None of the amici or the appellant cite one single case applying that concept in an exemption, other than it may be passing with no analysis. I mean, there's literally none of it whatsoever. It only applies in valuation cases. So that's why this case, and I appreciate the importance, well, it doesn't matter what I appreciate, it is important that this panel, that the en banc court side with the panel ruling. It does have significant effect out there in the community.
But that's just a means of how we get to the word affirmed from your perspective. I mean, you frame this as a cross appeal. In my view, it's not really, unless you're trying to alter the judgment. And the judgment that's here on appeal is in your client's favor. And if this court affirms the judgment by either one of these avenues, you win. And you're not asking us to change the trial court's judgment, correct?
The ultimate judgment that the Academy prevailed, of course not. But the judgment does state that the decisional finality doctrine does not apply.
But it does so not in a way that harms your client, as long as the judgment is affirmed.
I just can't get past.
I mean, you're not asking us to reverse anything the trial court did, right?
Not the result and not the finding that the exemption applies, but the finding that decisional finality does not apply. I don't see how that makes any sense, that decisional finality would apply if the circuit court or this court ruled on the exemption. It logically negates that argument, which is the fundamental argument he makes, that every tax year stands on its own in an exemption case, with no legal support for that concept in an exemption case, certainly in an evaluation case. May I address, I'm going to address a couple things from the briefs that to get to. The amici are wrong when they claim that the government leasehold exemption and the agriculture classification statutes make decisional finality inapplicable to the VAB process. First, those statutes make clear that VAB decisions are final unless appealed. And actually, each of the amici briefs fail to point out that those statutes use the disjunctive word "or" when they talk about value adjustment board or judicial determination in those situations. And so I can be a little more specific about that. Second, those statutes merely change the application requirements for government leaseholds and for the agricultural classifications. Because remember, the general setup is that every year taxpayers or property owners need to file something with the property appraiser unless the county commission has opted out of that. So the default is that everybody's got to file an application unless the county commission defaults out. Well, these two statutes, the governmental leasehold and the ag classification statutes, specifically state that you don't have to, those folks don't have to file applications. In the ag situation, there is actually a requirement that they do, the property owners have to take some action, I believe. But, and specific reference to the governmental leasehold exemption is telling in this regard. In that case, that statute actually sets up a unique process that's a little different. What it says is that for a government leasehold exemption, an application has to be made, and then the property appraiser makes findings of fact and sends the findings of fact to the value adjustment board, which then makes the final decision. Or there could be a judicial determination, because the statute says, or judicial determination, right? So if the property appraiser doesn't like the ruling, or the taxpayer doesn't like the ruling, they can take it to the court. And once a decision's been made by the VAB, if unappealed, or by the court, if appealed, then the government leasehold folks don't have to reapply every year. So they're exempted out.
How does
doesn't
that
that work
argument
against
help
you?
your point? I mean, I thought the point the Miki were making was these are examples of when the legislature wanted the VAB to have the final say for this tax year and forevermore, it knows how to say that, and it didn't do that in this exemption context. So how does that argument you're making help you?
No, because what they're doing is they're talking about applications. They're talking about applications, and it's reaffirming the concept that the VAB's decision is going to be final if it's not appealed. Because it's literally, the amici argue on this governmental exemption and ag exemption, they argue that those statutes state that the court is finality, that the legislature intended the court to be finality. A simple reading of those statutes make clear that is not the case. They're just simple it's just stating that if the VAB or the court rules this way, you don't have to file an application, or you have to do it differently than the default, which is everybody files applications.
But I guess their point was, in this context, if the legislature wanted the result that the panel got to here, the legislature would have written, if the VAB or the court determines an exemption applies, then it will apply from here more. I mean, I think that's the argument they were making. I don't know if I buy it, but I'm not sure how that argument helps you.
Well, their argument was that those statutes say that decisional finality only rests with the court. And they don't read the disjunctive in those statutes. That's the point I'm trying to make for you. And moreover, those statutes are not talking about, they're not centered on, they're not intended to deal with at what point does the decisional finality occur. They recognize that the finality could occur just at the VAB or at the judicial level. But when there is a finality, that they don't have to file this application every year that other any of the other types of exemptions apparently do have to file every year. Amici are arguing correctly that the taxpayers will be hurt by the panel decision. This taxpayer, this property owner has been harmed exactly as decisional finality is intended to prevent. Without any change in the law or facts, the Academy's been forced to relitigate 4 times after prevailing in 2008. And I would submit that what better reason do you need to apply decisional finality here? The legislature does not intend absurd results. And living with this case for the 11 years that I've lived with it reminds me of that adage about doing the same thing over and expecting the same results. The panel decision was correct, and I'll reserve the balance of my time.
Well, it's 55 seconds, and I may not give it to you, but that's okay. We'll see how it goes.
Thank you.
I believe appellant Cross Appellee has a minute 42.
46. Now, first of all, the statement, I mean, I believe I initially said what he said I said, is that if the circuit court rules, no, it's right, and I withdrew, I thought, hopefully I did, because the only case on that issue, and there is one, is out of the 4th DCA, and the Broward versus the telephone company, where the court specifically overturned, or looked at and said that the trial judge had written the same value the second year as the first year in the same language, etc. The taxpayer said you can't do that because of res judicata. And the court cited, res judicata does not apply even in circuit court decisions of taxation issues under the code. So no, my opinion is the circuit court decision is not, quote, finality in the sense
What
of
about
res
this court?
judicata, et cetera.
What about this court? If this court...
Of course it is. This is an appellate decision. We're in the 1st DCA. Now, in the 3rd DCA, I would be bound, or the trial court would be bound by a decision you make. It could go to the 3rd DCA to see if they wanted to entertain conflict. But if you ruled, even in my county, in Monroe County, that court down there, the trial court, would be bound by your decision. But that doesn't mean I couldn't appeal it to the 3rd DCA, trying to entice them to conflict.
But your position, just to be clear, is if the litigation here went to the circuit court, as it did, the circuit court rules they're an educational institution entitled to the exemption, no appeal was taken to the DCA, your position is that circuit court decision is not entitled to res judicata, and your property appraiser
Yes.
could deny the exemption the following year.
To me, that's what the 4th DCA said. That's what the law has been. In effect, yours was circuit court decision that you held the same thing in Macedonia Davis. That was circuit court, not valid. And you said the circuit court could not bind future taxpayers, future years, and future decisions. That didn't apply res judicata. And also, I want to correct the law in Florida, section 100242, private schools. It provides, and section 40 and H, it is the intent of the legislature not to regulate, control, approve, or accredit private educational institutions, period. DOE does not do that. It's what the Bush court reiterated. There was actually another body set up as a division of DOE, which if they were going to accredit or certify or anything, would be under that division in DOE. They didn't. We have a commission. If you look at the definition of commission in Chapter 20, the definition is a totally separate body. They claim they're not regulated and part of DOE. Second, there's 2 rules that I thought underapplied in exemption cases. In that, first of all, they're strictly construed against granting. Here, their argument, and we're proposing to change one word, certification, to licensure. Change it from a noun to a verb, license to licensure, then to certification, and then to add another body, the commission, as being DOE. To me, that's not strict construction. If the legislature, who fully created all of these bodies, wanted to grant licensure or a license under the commission, it certainly could do so. But it didn't, because it emphasized on the quality of education to define an institution, not the reporting. That's what, if you read the beginning part of the legislature opted that DOE's only requirement in private schools was disclosure.
Counsel,
So that
what significance should we give to the amicus brief filed by the Department of Education that says, in effect, the position that they take?
In reading their brief, and I believe I pointed it out, I could go into a lot of details, but they cited as one basic thing is that the commission is just like a council, etc. They failed to read that statute because in the section they referred to, it talked about councils, etc., and then accepted the commission out specifically that it didn't apply. Now, that was the basis of their argument. The commission is just like these council or et cetera in DOE when they weren't, by reading the statute.
All right, Counsel,
DOE is
I've given you 3 extra minutes. Can you go ahead and conclude?
Is there any other question that I can answer? If not, I would thank every one of you for putting up with us.
Thank you, Counsel. Does the appellee see any need to use their 55 seconds? If you do, come on up. Insert rebuttal only on the administrative finality issue.
Yes, absolutely. This Macedonia case, this court, the panel ruled because Macedonia did not timely challenge the property appraiser's notice, the circuit court did not have jurisdiction over that issue. It's like the second full paragraph, and then the next paragraph, while reversal on these grounds moots the other issues raised in the appeal, the court's going to go on to give some guidance to the trial court. So I wouldn't carry that any further than the holding of that case. Finally, the legislature used the word appeals in this statute. When the legislature uses the word appeal and establishes a quasi-judicial body, it intends for decisional finality to apply. Thank you.
Thank you, Counsel. Thank you both for your arguments. The court's in recess.
All rise.